Okay, Mr. Serrano, I understand that you want Ms. Bond to be showed up right now, or be seen right now, but she just showed up 3 hours late, so I was gonna handle some of these other matters.
Within discretion of the court, Your Honor.
Ms. Bond? Are you under the influence of any substance right now?
No, not at all.
Not at all?
Not at all.
Okay.
Only cough medicine. I was very sick. I've been calling into the court all morning.
Okay, ma'am, I'm not handling all that right now. We're not gonna address that right now. I just wanted to know if you're under the influence or anything.
No, right.
Okay, I'm gonna actually have you go over to probation right now. I'm gonna have you test right now.
Okay. Go!
Hand me my screen box. Now go free. Rah.
On the record, matter of City of Wyandotte versus Erica Bond, 24353.
Your Honor, let's get Mr. Serrano hearing as court appointed counsel on behalf of my clients, President of the Court.
Ms. Bond, your name, please.
Erica Bond.
Okay, well, ma'am, you were scheduled to be here at 8:30. There's a few things. You're scheduled to be here at 8:30 for sentencing on your plea to possession of controlled substance. You got here at, I don't know, maybe 11 or so. And you also were ordered to have contacted the probation department for a pre-sentence interview, which you did not do either. So we can't proceed with sentencing because you didn't meet with the probation department. So we're going to have to give a new date. But also, there are some concerns, Sam, that you are under the influence of a substance.
No, I'm really sick. I called in this morning to try and get the time I was supposed to be here because it didn't say it on my ticket. I left
Ma'am, this right here that you received while you were in, excuse me, it says the date on here and the time, 8:30 a.m.
I didn't get anything but
When were you released from jail?
on Saturday. They didn't give me anything but my release papers, honest to God.
And did you post bond?
Yes, I did.
Okay. And so,
And they just told me that I had court Wednesday, the 24th. They didn't say what
okay,
time.
ma'am, you know how to use a website, correct?
Yes, I do.
Okay. Well, you can look on our website. You can look it up under your name or the day of the docket. It will give you the time of your court date.
Okay, but the thing was, I was calling all day Monday and Tuesday, and I left a message to let you guys know I was in the vicinity of 2 kids with strep and 1 with COVID, and I didn't want to bring it into your facility.
Okay.
And you guys wanted me to do it by Zoom. That's it.
Yeah. You called all day Monday and Tuesday.
I need
okay, so
an answer.
Please listen. When you hear the recording that comes on,
I left a message.
do you hear the email address that is put forth on the recording?
No, honestly, I didn't, and I'm like.
Well, then you should have listened to it because you could have sent an email in. Because it's a much more effective means of communication,
I'm sorry.
given how we are short-staffed. And if you have a question on your court date or your court time, you can send that question in. In any event, I had you go over to the probation department to test today.
Yeah.
You would not keep the testing thing in your mouth. You kept dropping it.
No, I didn't drop it. She's seen me take it out and look, and I asked her if that was enough spit, and she watched me grab a whole blob of spit and just,
Ma'am,
she was.
the note I have here, she would not keep in mouth and kept dropping it. She was told by Courtney and myself to keep in mouth with saliva. She didn't do that.
I will go right on site right now and do a urine test if you'd like.
That's what you're going to do.
Okay.
We have to set this for another date anyway.
Okay, I'll go do a urine test. No problem at all. If there's any way I could have till tomorrow to set up a ride to get there,
Oh, no. No. You got a ride here today, right?
Oh, no, I would, but I'll walk. That's fine. I mean, it's only a mile or 2. It's about 2.5 miles from my house. I mean,
Then arrange for a ride, ma'am, arrange for an Uber,
No
something.
problem, no problem.
May 15th at 9:45 a.m.
Okay. Oh, I'll be here.
But you also have to have your PSI. So I don't know how you think you're going to do all that today. Well, let me just clarify. You want to stop at probation before you leave, set up a PSI interview date. And I believe that you cannot go test right this moment. I think you have to wait until 4 or 5 o'clock. So you should be able to get all that done.
Oh, okay.
15.
Yes, I have some serious concerns, ma'am, that you are under the influence of something right now.
No, I cannot even breathe. It's just my nose, my eyes. I'm probably.
And if you have a mask on, then why aren't you wearing it? You have a mask on for a reason.
This is making it even harder to breathe.
So why are you wearing it around your ears then? I mean, why do you even have it if you aren't going to use it?
No, I was using it when I was in the hallway and people
Okay.
were walking past, but it muffles my voice when I came in here to you, so
Okay, I can hear you just fine with it on, that's fine, yes. Okay, bonding conditions are continued, stop at probation for your PSI.
Okay.
Thank you, Your Honor.
This is the matter of the city of Riverview versus Brent Mahala, 24195.
Ready, Your Honor, thank you. Mr. Mahaloff is approaching. Good morning, Your Honor. Ellen Michaels, P67943, on behalf of Brent Mahaloff is present in court. Today's the date time set for arraignment and pre-trial.
Okay,
For purposes of arraignment, I'll waive formal reading and stand my client mute.
all right, thank you. Mr. Mahala, your name please? Okay, sir, I'm recording on this device here, and I absolutely can't even hear you myself, and I know for sure that my device is not picking you up. So if you can speak directly into the microphone with your name, please. All right, thank you. And is there something going on with you right now, sir?
Can I speak on his behalf? It's a little hard for him to speak.
Okay,
He about a month ago, suffered 3rd degree and 2nd degree burns over his body. We had adjourned this case and sent a letter to the court from the hospital. He was just released on April 4th, and he is, in a lot of pain being here today.
okay. Okay, so we will try to move this along as quickly as we possibly can. And as to the arraignment, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And as to the pretrial.
As to the pretrial, we don't have discovery yet. We did send a request to the prosecutor who filled out an order, sent it over to the court, never received it back, filled out a new order today to be signed by the court for myself to get discovery, and the city attorney doesn't have discovery either.
Okay, well, let me clarify a couple things. So, counsel, when somebody's asking for discovery, when an attorney's asking for discovery, if that request goes to the prosecuting attorney, this court doesn't do anything with that. I know some courts apparently act as a liaison between the prosecuting attorneys and defense attorneys, but this court does not.
I must have misspoke. I sent a request to the city attorney who filled out a discovery order for the court to sign for me to take to the police station.
Okay, you did that prior to today's date?
Weeks ago, yes. He sent it to the court a week or two ago as well and didn't receive it back. I followed up with him several times. So he filled out a new one today.
Okay. Well, that's interesting because this is the first I'm seeing it.
I understand. There was an email chain. I saw that he did send it to the court.
I'll have to follow up on that because I do not recall seeing that, and he's here every Monday, so I'm not sure how that occurred. So I will look into that to see what happened with that. And are these burns as a result of this incident or something different?
Completely different.
Okay. Well, the court has signed the order of discovery, and we can, would April 22nd be sufficient, counsel?
I'm checking. April 22nd, is good, Your Honor. Would it be possible, for my client to appear over Zoom, given his medical condition?
Well, counsel, not necessary, I mean, your client's here today, I presume he leaves his house for medical appointments and whatnot. I understand it's difficult for him, but is it easier to go a little bit later in the morning for him as opposed to first thing in the morning?
Is that easier for you? Yes, that would be easier, thank you.
All right, so we can do, April 22nd, and we can do a 10 a.m. work?
Do you mind if he sits, Your Honor, briefly?
That's fine, yes.
10 a.m., thank you. And also, Your Honor, another request that we have is that my client has a pending case in Los Angeles. We are requesting permission for him to travel to Los Angeles only for court from April 15th through April 19th. It gives him a chance to get there, go to court, and then fly back.
Okay. April 15th through April 19th.
Correct.
When is his court date?
17.
Court date is the 17th.
And what is that court date for, counsel?
It is for a domestic assault allegation that he is fighting. He is an attorney I'm in contact with there, and I expect that case to go to trial. He was in Los Angeles on vacation. He doesn't live there or any contacts there. He's just simply going to appear in court in
Hermosa Beach.
Hermosa Beach, California.
Okay, and so, when did that, what is the date of that incident, counsel?
Approximately 5 weeks.
Approximately 5 weeks ago. In the file, there might be a notification of it, because I know they ran a recent check on him for this morning. It is the first court date in person on the case. He's an attorney who's a colleague of mine who I'm in constant contact.
Oh, yes, there we go. A felony, correct? Well, it's labeled as a felony for their purposes. I don't know what it is for different states. Okay, Okay, so that's from,
Based on my
February
conversation
13th.
Based on my conversation with the attorney, it is what we would consider a misdemeanor.
Okay, just so you know, it says severity on here, it says felony.
I understand.
So I'm just, that's why I asked that question.
I understand.
And so that date of offense is February 13th. The date of this offense is February 7th. And then he has something pending in Oakland County, correct?
No, it's in Wayne County at, out of the Woodhaven District Court.
Okay, and so what does that matter?
That's a carrying concealed weapon. It was a antique sword was in his car when he was pulled over for a traffic violation. That's set for probable cause conference on April 16th.
Okay, I'm also showing a drug charge as well, but it's showing that there was a bench warrant issued. That's why I'm asking.
Out of where?
33rd.
That warrant's been set aside. That I handled that for a carry concealed charge.
Okay, so counsel, just so you're aware, this is just from this morning. It's still showing in there. So you may want to contact 33rd because I'm looking at bench warrant issued.
I'll contact the court.
I'm not suggesting that you didn't handle it,
Believe me.
but somebody may
Yes.
not have addressed something.
Understood.
Okay,
Understood.
my other question is, there's something out of the Sixth Circuit Court where there's also a warrant, protected person Clarissa Jernigan, so it looks like, or an injunctive order at least, a domestic person protection order, that's showing that there was a warrant of the Sixth Circuit Court from February 27th.
Okay, I'll look into that. It's possible that she is the woman who was in Los Angeles with my client who filed the charges there. And it sounds like it's possible when she got home, saw that. This is the first I'm learning of that. It's the first my client is learning of that as well.
Well, it's showing it's not served, but there's a warrant for something from the Sixth Circuit. So I'm not sure exactly what that what that warrant is for, because he wasn't served, it shows in here, he hasn't been served with the PPO. And, so unless there was a violation alleged, I don't know.
He's been served with a PPO. And again, this is the first I'm hearing of a warrant out of their.
Share back and say.
I'm sorry, what was that?
We don't know what the warrant is for, Your Honor.
Okay, and so, your client, you indicated has, second and third degree burns. Is there something pending with that, or is that something different?
No, that was an accident in his home. It's unrelated to any criminal activity.
Okay, and so are you on probation? Well, you're on bond out in Los Angeles. Correct? Or has he appeared in Los Angeles yet, or this is the first appearance?
It'll be the first appearance. He had
Actually, I'm sorry, let me, counsel, sir, you can move on to the other tier, and then you can, and that has wheels, so I'm gonna have you slide closer to here so we can hear you better and adjust the microphone. Thank you.
He has not been in California on the case. The attorney out there adjourned the arraignment and pretrial that had been set in March because he was still in the hospital. He was arraigned in Woodhaven, and that he's on bond in Woodhaven.
Okay. And that's not the one, there was one in December, but that was, your client was not prosecuted on that matter. This is the one from February 21st.
You're talking about?
For Woodhaven.
Yes. Correct.
Well, it's interesting that your client has nothing, and now all of a sudden, in a month, he has a lot of different things he's facing. And that the allegations in this matter are 0.215 after an accident whereby it's alleged that he was hit a pole, an electrical pole of some sort. That's why I was asking if the burns were as a result of that. I wasn't sure.
I understand, Your Honor. It was not. The burns were a result of something completely different.
Okay, and so I'm going to state again for the record, the request for your client to appear via Zoom is not granted. Have to appear in person, especially given the fact that he can travel to Los Angeles and back. He can certainly travel from Brownstown to Wyandotte without any issue. And he has to be there 2 days before and 2 days after. And who's traveling with him? Or is he traveling by himself?
No, it's not me. Oh, he has a person traveling with him who will be assisting him.
Associate.
Do you need the name of the person? Is that what you're asking?
No.
He'll be traveling with a companion who will assist him.
And the tickets have already been purchased, counsel?
I'm sorry?
The airfare has already been purchased?
He purchased them, but I did advise that he needed to make it refundable because I knew we had to come and ask permission first.
Okay. So here's the concern of the court. The concern, there's something going on with your client. I'm not really sure what it is. I'm not sure if there's some drug issues, some alcohol issues, some mental health issues. I don't know. I don't know what's going on. But for somebody, your client is 33, no prior criminal history, and now he has all these issues going on. All within a span of a few weeks, quite frankly. There's something going on. So the court's going to grant your client permission to travel to California for the purposes of his court matter. I'm slightly confused as to why he has to be out there 2 days before and 2 days after, but
I can address that. His flights are canceled, they're delayed. I don't want him to be in a position of violating if he gets stuck.
that makes sense. Okay. All right. The court is going to order a $10,000 personal bond in this matter. The court's going to order an alcohol tether. The court wants to ensure the safety of the public as well as Mr. Mahalov. And given the allegation in this matter of a .215, that's a significant level. The court's going to also have you participate in random testing, sir, because I'm making the presumption that you're not currently testing. Is that an accurate presumption?
Yes, Your Honor.
Okay. So what that means is that during the time that you're in California, well, you're going to be taking the tether with you. I mean, that's going to be on you. That's
Yes,
traveling
sure.
with you.
Yes.
And the random testing, you're going to have to coordinate with our probation department. You're not on probation, but they're the ones that coordinate the testing. You're going to have to coordinate with probation to make sure you're testing in a facility out there that's similar to one that we have back here that we would be using.
Yes, Your Honor.
My client also has current prescriptions for pain medication as a result of his injuries. I'll make sure he brings copies of his prescriptions
Yes,
to probation.
yes, yes. He may have to also turn those into the testing facility that he would be utilizing here as well.
If they counter, will they give him all the instructions of where he needs to go and who he needs to
Yes,
show
he'll
up?
report to probation to get that all set up, as well as to get his tether. So, other than, well, if you were to test today, what's in your system today, sir?
Okay.
Not any of your pain medication?
She's asking about what pain medication.
Pain medication, yes.
Correct, what is gonna be, what pain
I
medication?
don't know what it's. Hydrocodone.
Hydrocodone?
Yes, yes.
Okay, and are you taking that as prescribed?
Yes.
Is that the only pain medication you're taking?
Valium,
Okay, you're taking that as prescribed as well?
correct. That's prescribable.
Okay, and so your flight leaves April 15th and returns April 19th, correct?
15th, 18th,
Oh, the 18th he comes back, okay.
correct.
I wanted the extra day just
Yes, Your
in
Honor.
case there was a problem.
Okay. And that's okay, in the event that, I'll give him permission to travel the 15th to the 18th, in the event that there is an issue with this flight, I presume he'll be communicating with you and then you can just send that communication to the court.
Yes, Your
Yes,
Honor.
Your Honor.
All right, anything else, counsel?
No, Your Honor.
All right, so please have a seat over in probation and somebody will be with you shortly, sir. And they'll get you information regarding your testing and your tether, okay?
Yes, Your Honor.
Thank you very much.
All right, thank you. Have a good day. All right, and then we are on the record in the matter of City of Riverview versus Brent Mahalov, 24195. Counsel, I see there's two attorneys for Mr. Mahalov.
Son Jamil Kuja on behalf of Brent Mahalov.
All right, thank you. And then Ms. Michaels, good morning.
Good morning. Thank you so much, Attorney Ellen Michaels, on behalf of Brent Mahalov, who is present over Zoom. Thank you for allowing us to appear over Zoom this morning. We agreed to do that.
Okay, and so Mr. Mahalov, your appearance, your name, please.
Mahalov?
I'm sorry, can you say that again, please?
Brent Mahalov?
Okay. All right, well, so today's the date, Mr. Mahalov is in custody, and so there's a bond violation that is now brought before the court. And counsel, you've been made aware of what those allegations are for the bond violation.
Yes, Your Honor, I received an email this morning from the probation agent.
Okay, and so what is it that we the doing today, counsel?
What we are asking is that my client be given the opportunity to have the alcohol tether put on today. And we have quite a bit of information we can share as to what brought us here. My client has been in touch with us during the course of this.
Okay. Okay, and we're gonna get to all that, but as to the bond violation, is your client pleading guilty or not guilty?
He'll be pleading guilty to the bond violation.
Okay, Mr. Mahalov, please raise your right hand. You solemnly swear.
Actually, can I be more clear before we do that, please?
More clear? Okay.
He'll plead guilty. He'll plead guilty to the bond violation as regards to not getting the alcohol tether put on and missing a test. The allegations that he was under the influence, he's not pleading guilty to that. I don't have enough evidence that he's not pleading
Okay.
guilty to. Thank you.
Okay, so we are going to proceed on the alcohol tether, failure to enroll, and the failing to appear for drug testing. So that's what we're going to proceed on. So please, Mr. Mahalov, raise your right hand. Do you solemnly swear or affirm? Mr. Mahalov, please raise your right hand.
Ellen.
Do you solemnly swear or affirm the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes.
All right. As to the bond violation that you were ordered to enroll with the EMS alcohol tether and failed to do so, how do you plead?
Guilty.
And as to the allegation that you were ordered to participate in random drug testing and failed to appear on April 23rd, how do you plead?
Guilty.
And you understand that you have the right to have a contested hearing in these matters, and by entering into a plea of guilty, you will not have that contested hearing.
Counsel, can you explain or interject? I don't
Yeah.
understand.
Judge, if we could have a breakout room, please, to explain this part of the proceeding a little bit further.
Okay?
Thank you.
Okay, and so we are recalling the matter of Brent Mahalov, 24195. And counsel?
Thank you. I thank you for the opportunity to speak with Mr. Mahalov to explain more clearly the procedural steps. We're ready to move forward on this plea to violating his bond conditions.
Okay. All right, and so, sir, you're still under oath, and so, sir, you understand that you do have the right to have a contested hearing in this manner. By entering into a plea, you will not have that contested hearing.
Yes, Your Honor.
Okay. You also understand the possible penalty as a result of your plea today, correct?
Yes, Your Honor.
All right, you understand this court could revoke your bond, the court could reinstate your bond, the court could continue additional conditions. There's a whole array of things this court could do. You understand all of that, correct?
Yes, Your Honor.
And knowing all that, you want to continue with your plea.
I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea today, sir?
No.
Okay. And counsel, would you like to voir dire your client, please?
Yes, thank you. Mr. Mihailov, on April the 9th, 2024, did you fail to enroll and get an alcohol tether put on your leg on that date?
Yes.
And you were in court that date and you were ordered by the judge to do that. Is that accurate?
Yes.
And you understood that the judge was ordering you to get an alcohol tether put on that date, correct?
I misunderstood.
So we were in court that day. We were in court that day.
Correct. Yes. Yes. The answer is yes. Yes.
Okay.
I'm sorry.
And when we were in court that day, it was explained to you to get an alcohol tether, correct?
Yes.
And it was explained to you to take care of it right away, correct?
Yes.
Okay. And you were ordered to appear for drug testing on April 23rd, 2024, correct?
Yes.
And you failed to appear to do a drug test on that date, correct?
Yes.
I'm satisfied.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violation. And counsel, as to sentencing on the bond violation.
Thank you, Your Honor. We ask that, Your Honor, sentence him to this 1 day serve that he's now locked up and in custody, and reinstate his bond for the following reasons. After he left court, on April 9th, when we were all in court on that date, Mr. MAYHEM did go to the hospital, and he spent several days in the hospital due to the burns over his body, which Your Honor has been made aware of, as we had originally adjourned the case when it first was in the courtroom, and given documentation that he was in the hospital, and he did go to the hospital again. As soon as he was released from the hospital, he did travel to Los Angeles, as he was permitted by the court, in order to appear in court in Hermosa Beach, which he did do that. He has been in touch with me, and Mr. Kruger could speak to being in touch with him, but he has been in touch with me the entire time with regard to where he is and what's been going on, and he's really been having a difficult time managing his health through the burns all over his body and appearing in court. And Mr. Kruger, I believe, may have something to add with regards to Mr. MAYHEM.
Correct, Judge. He's been in constant contact with both of us. I think between the hospital visits and then having to appear in Los Angeles for his court case that's pending there, is really no excuse. But it was a little overwhelming for him, and he wasn't able to put the alcohol tether on. Given that he's in custody, I'd ask the court to consider just keeping the bond as it is, given that he's in custody, and they can just put the tether on today before he's released.
So here's a few concerns this court has. So there's a reason this court ordered alcohol tether on your client. There's also a reason this court ordered your client to participate in random testing. And also a reason why this court ordered your client to test while he was in Los Angeles at least one time. Did he do that?
He did not.
We did not.
Of course not. He has zero regard for court orders. He's on bond in Los Angeles. He has this matter here now in the, so here's, if I recall correctly, he was on vacation in Los Angeles, and he ended up with a very serious felony charge, inflicts corporal injury. Then he's back here in the state of Michigan, where he then picks up this offense on February 13th. Let me just clarify something. No, this was February 7th. The date of this offense is February 7th. In high BAC. Then I think is when he went to vacation in Los Angeles. He picked up that charge, because I think that date of that offense is February 13th. Picked up that felony charge. Then he's back in Michigan again, and on February 21st, picks up a CCW felony charge in the 33rd District Court. Mr. Mihalov claims he was confused. I'm not sure what he was confused of. This court was very clear. This court allowed you to leave on a personal bond, sir, and get the tether on your own. You've shown you cannot do that. This court also ordered you to test randomly. You didn't do that either.
No, Your Honor,
I was in the... This court, sir, this court did not have to permit you to travel to Los Angeles for your court date. It allowed you to do so because you were supposed to have the alcohol tether on. You were supposed to have tested while you were in Los Angeles. You did none of that. You have complied with zero bond conditions. Zero. And now your attorneys are arguing to allow you to be released again because you're going to comply with the conditions. This court has zero confidence you're going to do that.
My intention was today, I was sincerely and literally on my way to get the tether, which was to the best of my ability. Yesterday I was in the hospital. I have no excuse, no valid excuse. However, I'm not disregarding what you're saying, Your Honor.
So let me ask a question. How is it that you're currently in custody?
The FBI arrested me on the way to the tether facility in Brownstown.
They arrested you on the way to the tether facility.
Yes.
Detective Sergeant Gentry, do you have any information regarding that?
Yeah, sure. I have the agent in charge, if you would like to speak on the record with her.
Oh, okay, and Detective Sergeant Gentry, your name for the record, please.
Detective Sergeant Derek Gentry, the Riverview Police Department, Your Honor.
All right, thank you. And then, Agent, if you could please state and spell your first and last names.
Special Agent Taryn Tashner.
I'm sorry?
Special Agent Taryn Tashner.
Okay, can you please spell your first and last names?
TARYN TASHNER.
Okay, all right, and how was it that Mr. Mahalov was taken into custody?
During an ongoing FBI investigation, it was brought to our attention that he had violated the conditions of this bond when he was traveling to Los Angeles. On April 17th, he made a phone call to Hermosa Beach Police Department, and when they responded, they noted that he was heavily intoxicated and told him to get back in his house. Several days later, which would have been Friday, April 19th, I believe, he was attempting to board a flight to fly back from LAX into Detroit, and the Delta representatives noticed that he was so heavily intoxicated and taking pills that they would not allow him to board and refused him from boarding, and he was removed from the airport at that time.
So how did he end up back here in Michigan if he wasn't able to board? He was able to board at a later time?
He had to board with a different airline that had not banned him, and then he was able to fly back.
To the Greyhound as well.
And as he's saying, he also took a Greyhound.
Okay, so when did you return, thank you, Agent Tashner, when did you return Mr. Mahalov to Michigan?
I'm not clear on the exact date. I'm sorry. I contacted Ellen or Jamil, if you could chime in. I
can chime in. Good. Judge, he actually came right. He came right to court on Monday from the Greyhound station in Toledo by a ride share that we helped him arrange.
Thank you.
What date was that, Counsel?
That was Monday.
Monday, the 22nd of April.
Monday the 22nd. And
Yes,
he was to return by April 19th to the state of Michigan.
That was correct, and he notified us over that course that he was having problems traveling, and we advised him to get back. And this was the quickest he was able to get back, given his inability to fly.
Judge, I believe what he did was.
And was there any communication with the court regarding any of this issue? And there in a request to extend his return to the state of Michigan?
Judge, it happened from Friday. I think the order was that he returned April 19th, which was Friday. And when he wasn't able to board, he had court on Monday, on April 22nd. We really had no chance of doing anything between when we found out and when he had court on Monday. I believe he flew, the only flight he could find was to Chicago. Then he took a Greyhound bus from Chicago to here and basically came straight from the Greyhound bus station straight to court. So
I did everything within my power.
Well, sir, let me just say this. Right. And I understand that there are allegations that have not been necessarily acknowledged or admitted one way or the other. But I have to say, counsel, when somebody is not permitted to board an airline based on certain allegations and banned from that airline, that's problematic. And that would be exactly why this court ordered the conditions it ordered. And I will say this, had I not had to have had somebody cover for me for Monday morning unexpectedly, Mr. Mahalov would have probably been taken right into custody on Monday for his failure to comply with this court's orders. So let me count the ways, Mr. Mahala. This court ordered you to get an alcohol tether fixed on April 9th. You didn't do so. This court ordered you to participate in random testing. You were to test on April 23rd. You did not do so. You were to test while you were in Los Angeles. You did not do so. You were ordered to abstain from any alcohol and drug use that was not prescribed. You failed to do so. You also failed to return to court on April 19th, or return to the state of Michigan on April 19th.
As you are aware, I was unable to.
Don't interrupt the judge.
Oh, I'm sorry, my mistake. Sorry, yeah.
For those reasons, this court is not going to reinstate the bond. The court's going to order Mr. Mahala to remain in custody. And the court is actually going to send you to treatment, sir. You need some assistance in maintaining some sobriety. So this court is ordering you to treatment. If you request. If you don't request them, you can send the Wayne County Jail.
Understood, Your Honor.
And so, counsel, I see here that this matter was adjourned to May 22nd. So we can adjust that date based now on your client's incarceration if you would like.
Yes, please.
So the court's going to note that defendant's bond is revoked. The court will will state that defendant may be tethered to treatment through Wayne County Jail if requested. I will mark the file medical, counsel, based upon your client's medical issues.
Thank you, Judge.
And should you want that request to be made at the jail, or
your client would have to make the request at the Wayne County Jail.
Okay, you make that request at the jail for drug treatment.
Well, alcohol and drug treatment.
For alcohol and drug treatment.
And counsel, we can adjourn this. Right now it's on May 22nd, which I'm not sure why it was set for May 22nd, because that's a Wednesday and this should be a Monday. So we can do May 13th. Would that be sufficient time to, it appears as though there needs to be some medical records reviewed?
Correct.
Yes.
Okay. So would May 13th allow you sufficient time to do that?
I don't know that. And I'm
probably not.
Okay.
It probably will be longer than that to get the records.
Okay, so we'll keep it at May 22nd. If you receive the records prior to that and you've had time to review, then you can email into the court and just indicate that your client's currently in custody. It was set for May 22nd, and now the court indicated we could move it up potentially to a sooner Monday, but it has to be a Monday if the information is received before that.
Yes, Your Honor.
All right, so we will, so the pretrial, okay, I said May 22nd, it can't be May 22nd, that's a Wednesday,
correct.
May 20th. So we'll do May 20th.
At what time, Your Honor?
We can keep it, we can do 10:15 a.m.
I'm actually not available May 20th. I'll Mr. Cringe, are you available May 20th?
I'm sorry, I'm not. I started jury trial May 20th. It's a one-day trial.
Well, okay, the next Monday is Memorial Day, so that we will not be here for that day. So that puts us to June 3rd.
How about we go to May 13th?
Let's do May 13th, Judge. And if issue, we'll address it that day.
Okay, and I don't know if he has another date with 33rd or what happened on the April 16th date. Oh wait, we're supposed to have a PCC on April 16th. Did you zoom in for that on the 33rd?
Yes, he did, Judge. He entered a plea to disorderly conduct, and sentencing is this coming Tuesday.
Okay, well then you may need to notify 33rd so they can do a writ, so they can at least have them zoom in from Wayne County Jail or treatment, whichever it is wherever he's at. I will make sure I notify them. All right, and then I will also do the custody order as well. I'll find that here. Okay.
And on May 20th, that's at 10 a.m. You said?
13th.
No, you said May 13th.
At what time? I'm sorry, right?
10:15.
10:15. Thank you very much.
Okay, anything else?
No, Your Honor.
So, yeah, thank you.
Thank you.
All right, thank you. Have a good
Thank
day.
you. You too. Bye-bye.
That's
Thank you, Your Honor.
Thank you. All right, off the record. Thank you. And this is a matter of Wyandotte versus Teresa Danes, 24137.
Mayor. Good afternoon, Your Honor. Neil DeBloy here on behalf of Teresa Danes, who stands to my right. Would you state your name for the record, please?
Teresa Danes.
All right, thank you. Please remove your hands from your pockets. And so today is the date scheduled for sentencing on your client's plea to possession of controlled substance. The possession of drug paraphernalia and speeding charges were dismissed. And counsel, do you have an opportunity to review the report and recommendation? There's also a bond violation as well.
Yes, I'm aware of that, and yes, we did carefully go through the pre-sentence investigation report and we have to comment.
Okay, and as for those comments, counsel?
All right, first of all, on page 1 of the PSI, it says under criminal history 11324 Southgate. I'm advised that matter has been dismissed without prosecution. It's not pending, it's been resolved.
Yes.
Okay, you're aware of that. All right. In addition, the client advises that are not included under her health conditions, treatment history, whatever you're called. She recently been diagnosed with ADHD, is under pending doctor's care for that. She also has a long-term condition of psoriatic arthritis. Is that correct?
I'm sorry, I didn't hear what you said, ma'am.
She said yes.
Okay.
There is also no reference to the fact that she, oh, maybe I'm wrong about that. She does have one child at home. It is referenced, just pointing that out. She has one child at home. She still take a minor child that she still is responsible for. And finally, a question only with respect to the recommendation or plea, there was a question whether or not she qualified for 7411. This is apparently the first time drug offense for her. There's no reference to that in the recommendation that was part of the plea bargain. So I don't know if that's been, she's not eligible or it just was overlooked or.
I may have just been overlooked as far as that goes, or maybe they're waiting to see what was going on with the Southgate matter. But it would appear that your client is eligible under 25.136B, which is the local ordinance equivalent of the 7411.
Yes. So
because there are not any prior criminal or prior drug convictions.
Yeah, so again, to my review, it appears she's eligible. So we asked the court to consider that. With respect to other than in terms of factual modifications or amendments, otherwise the report is appears to be factually accurate. With respect to the recommendation, the circumstances and her eligibility for 7411, some additional information that I want to provide. She is in outpatient counseling with a program it's known as Work It. Is that correct? Work It, which involves, as I said, outpatient counseling. So she does have that assistance. It's also not.
And they randomly drug test me that as well.
Okay, and so what are your prescription medications?
I'm currently prescribed Provigil, and I don't have that yet in my system. So right now it only has positive suboxone, which I'm prescribed for.
Well, okay, here's my question. So you claim that you're prescribed Prozac, Suboxone, and Trazodone.
Yes.
So you were supposed to have submitted proof of those, but you haven't yet.
Oh.
And that you also use, I'm sorry?
I'm sorry. I probably have them in the car.
Okay, you also use Kratom and marijuana.
Not anymore. I'm clean and sober now.
Very good, because Kratom is just a legalized form of opioid, pretty much. I mean, you take enough of that at one time.
Okay.
And it has opioid effects. And so, and I don't even think that that's actually even FDA approved or not. I don't know. I don't think it is. And then the more you take, then you take more and more and more and more. And so, okay.
And again, if I may continue, Your Honor, with respect to the recommendations, the item 2 is incarceration. don't know that that's warranted in this instance, or that would do any good. I suggest the court is inclined to order incarceration to be held in abeyance, give her an opportunity to, she said, prove that she has been clean and sober, and revisit that in the future. That would be my request. Beyond that, it seems to be appropriate under the circumstances.
So, okay, we're gonna hold off on, all right, we got the end of the bond violation. Ma'am, please raise your right hand. Do you solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
I do.
All right, so you were ordered on bond on March 20th not to possess or consume any alcohol or drugs unless prescribed and to participate in random testing.
Correct.
Okay, so on March 22nd was your first test. You're positive for amphetamine, cocaine, marijuana, Suboxone. March 29th, positive cocaine, Suboxone, marijuana.
Well,
You're
down.
I understand that,
Okay.
but in any event, you don't have a prescription for cocaine.
No, but I told you in court that day that I
So-
would call the test for that.
Well, it wouldn't be that way 9 days later, ma'am.
Honest to God.
You failed to appear on April 15th. And so after those violations, counsel,
Your Honor, my client appeared to be guilty of bond violation with explanation.
all right. And so ma'am, after those violations, how do you plead?
Guilty. And my friend died that day.
And you've, just one moment, please, ma'am. You've gone over your advice of rights with your attorney, correct? And you understand that you have the right to have a contested hearing in this matter. And by entering into a plea, you will not have that contested hearing. Do you understand that?
Yes, I do.
Okay. Anybody promise or anything, threaten you or coerce you in any way for you to enter into a plea?
No,
And you understand the possible penalty as a result of your plea?
believe so, yes.
Okay, this court could revoke your bond, the court could sentence you to jail, the court could not sentence you to jail, the court could give you a fine, a mix of all of that. Do you understand?
Yes, I do.
And knowing all that, you want to continue with your plea?
Yes.
All right. And counsel, if you can please pardon your client.
Yes, Ms. Daines, you've heard the allegation, you read the allegations of the probation department that on the 22nd of March that you tested positive for certain drugs. You admit that?
I do.
And likewise, 7 days later, similar result, level reduced, 329.24. You acknowledge that you tested positive for those things.
The test says I did, I did.
And then again, on 4/15/24, they allege that you failed to appear. You acknowledge that you failed to appear.
I do.
You have an explanation for that, but you do acknowledge that you failed to appear.
I do.
All right. The court does find the plea of knowing, voluntary, and factually accurate. The court will accept your plea of guilty to the bond violations. And counsel, why should I not sentence your client to jail for the bond violations, multiple bond violations?
As she's indicated, this is so close to time to the time of her sentencing. He prepared to test today, working backwards from today. She tested on the 3rd and on the 10th, and only Suboxone. So there's other things that have been cleared from her system. Suboxone she has a prescription for. On the 15th, she may be better to explain. There is, I think there's verification attached with the bond violation. She did, no, it's a little bit confusing. She did attempt, or she did call and indicate that she had a problem getting there on the 15th. There is a note from the probation department indicating that she had called the Lincoln Park office and said the door was locked. They state the door was not locked, but apparently it may be a different door. We're referring to whether the door was new paint on the door. She did call 727, apparently, and she also sent an email. Maybe she could explain it a little bit clearer.
No, it was sent on April 16th, and there was a whole lot of stuff apparently going on the 15th. But ma'am, let me just say this, okay? You need to put yourself first and your sobriety first. Missing tests because of a friend being sick, and you're the only one that was able to visit him. No, you have two things in here.
Yeah.
One, a friend,
I'm his caregiver. And
a friend passed away from eating a cannoli.
with peanuts, yes.
And then the other one was your roommate was sick. And then you spent 2 days in Wyandotte Hospital and was released the day you had the test. So, well, I understand that life events happen, okay? You have multiple times during the day to test, first thing in the morning or in the evening. That has to be your priority.
I asked if I could make it up and nobody got back to me.
Ma'am, you have to make it a priority. Because a missed test is considered a positive test. And individuals miss a test because sometimes they miss a test for legitimate reasons, sometimes they miss a test because they think they're gonna test dirty or positive, and then they wanna have a makeup test later because now they know they're not going to test positive. So make it a priority to make your tests. Now, you did state, if I recall correctly, that you would test positive for cocaine on March 20th, okay? Your level on March 22nd for cocaine was lower than your level on March 29th. That's how I know there was new use. There was new use, ma'am.
I swear on my life, actually not.
Because you're presumptive positive on March 22nd, which is 150 nanograms per milliliter cutoff, okay? So you're right around there. Then on March 29, you were at 202 nanograms per milliliter. So that's where it shows new use.
Absolutely not. I've been clean and sober. I've never been happier in my life. Straight judge. I don't know why that is. I really don't. I really don't.
I'm sorry, please, I can't have you speak from in the court because you're not identified for the record.
I could test today. I haven't missed it. I fell off the wagon for a couple of weeks, but I've been pretty clean and sober for 4 years. And I had a bunch of stuff happen with this legal stuff, but I'm back to my sober life. And I've never been happier. Honest to God. It even says on the front page that the level's reduced.
On your marijuana, yes.
Oh, okay.
Your cocaine numbers went up. Well, the medication that you take, are you getting it from a pharmacy or are you getting it from somebody else?
My sponsor? Pharmacy.
Okay. What about the amphetamine that you took?
I don't know what that is.
Okay.
What's the correct drug name?
It just says amphetamine.
Could have been cocaine. I don't know. Not taking any street drugs or I made illegal. I've been to outpatient therapy. Just had it 2 days ago with counseling. I'm trying to stay sober for my son and myself. I'm trying to have a good life. I mean,
I understand that.
I did not reuse. I swear to you, I did not use again.
Well, ma'am,
I'm not going to risk my freedom for that.
The numbers show that there is new use. Here's what I'm going to do, okay? I'm going to order on the bond violation 10 days jail. I'm going to suspend that jail. I'm also going to order on the sentencing that there's reasonable grounds to Department of Sale 769.5 after hearing from Ms. Daines, hearing from counsel, reviewing the report, the recommendation, the bond violation. The court's going to order 24 months probation. I'm going to order the following conditions. And the court will also note that you're eligible for early discharge. You're also eligible under 25.136B. The court's going to order the following. You're not to violate any criminal law of any government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not using any alcohol or drugs unless prescribed, and you'll continue to have random testing. The variability of both of that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to order 45 days jail. I'm going to suspend that jail as well. So ma'am, what that means is that your jail right now is going to be suspended. If there's violations, you'll be serving that time. Okay, so whether or not you serve jail time is 100% in your control. You do. Put yourself first. Don't put other people's problems or concerns ahead of yours, because they're not the ones that are going to end up being in the Wayne County Jail. Okay? Your Honor. And we're going to do a jail review on both the bond violation and the jail review on the sentencing for the 45 days. We'll do this June 3rd. I don't want to go too far out. All right, at 9:45 a.m. All right, and also you are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so that you are able to maintain sobriety and prevent relapse. You are to participate in fan meetings once per month. The rehabilitative goal for that condition is to allow you additional support, network, and recovery resources. And you also are to perform 80 hours of community service. The rehabilitative goal for that condition is to help you further develop work and life skills and get back to the community. And ma'am, I understand that you're employed by DoorDash. I think that you may need to have a bit more stable employment, which would, okay. So I'm also going to order you to seek and maintain employment and provide proof of completing 20 job applications per week. Okay? All right, any questions regarding the conditions?
No.
All right, the court's going to order a $400 fine, $100 screening assessment fee, $1,200 supervision oversight fee. That's $50 a month at 24 months. Since you're eligible for early discharge, up to $600 of that may not be due. $300 for the cost of prosecution. Crime victim assessment fee, $75. Justice system assessment fee of $50. $2,125 is the total between both, or is the total for your fines and costs. You did post a $150 bond. Do you have any other money to pay today?
Sure do.
How much is that, ma'am?
$400.
Okay, so the court will order a total of $550 when you apply your bond and the $400 that you have to pay today. And then that will leave a balance of $1,575. Can you do $100 per month? What date of the month works best?
The first is fine.
All right. Since you're paying $400, are you still able to do that May 1st, or do you want to start that June 1st?
June 1st would be better.
Okay. All right, since I did indicate, ma'am, that you're eligible under for early discharge, so long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort for making full payment. Okay? Good luck to you, ma'am. Please have a seat over on probation and somebody will be with you shortly.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience left. Trust me, out of the day, I'm the one that needs to drink.